morning, Ms. Richards.
Good morning, sir.
Well, we're ready to go. Everyone is in the same places that they were before. I can tell you that yesterday you had just over 200 people watching. So welcome to them if they have as many today. And just to let you on the panel know the size of the audience that you've got. Ms. Richards.
Lovely.
Wants to ask you first about emergency treatment and the extent to which the requirements for informed consent might be modified in an emergency. First of all, is this right, that the fact that treatment is required urgently doesn't automatically or necessarily curtail the requirement for informed consent?
Yes, that's correct. If it's possible still to get informed consent, then informed consent should be taken.
Yeah.
And so if the patient is conscious or the patient is capacitous, although the circumstances in which you're explaining the risks may be less than ideal and time may be limited, it is still incumbent upon the clinician within those parameters to explain, in accordance with the principles you articulated yesterday, what the risks are, what alternatives there might be, and possible consequences of the different options. Is that an accurate summary?
Yes.
Professor Kerridge.
Look, I think it's broadly true, but depending upon the circumstances and the urgency of the emergency, if you will, that will certainly modify the type of consent that's gained, and it certainly won't be fully informed. It will be sufficiently informed or adequately informed. If, for example, somebody comes into an emergency department with a severe episode of asthma, they are struggling to breathe, they have capacity, they can understand how sick they are, they understand the situation they're in, they know they need treatment, but they are genuinely struggling to breathe. To spend the time before giving them a medication to open up their airways, explaining the risks and benefits of a bronchodilator would be absurd in the extreme. So I think it would modify the information that be given, and it may mean that what is simply given in the initial period is a justification or rationale for what's being done. So you're urgently and seriously unwell, you need this in order to breathe. And then when the person has recovered somewhat, then you can be given more information about what it was, what the risks are, what the benefits are, and how it's going to be used, and alternatives into the future. So the consent still happens, it just happens in a particular way.
Well, I would go a little bit further than Ian. So I think one issue is whether you can genuinely imply or there's implicit consent. So in Ian's example, you can imply consent to the bronchodilators as somebody who has asthma. But secondly, all of these values, such as informed consent, best interest, have to be weighed against each other. So if a delay was going to compromise the person seriously, then even though the person has capacity and is capable of giving informed consent, you might proceed with treatment. So if you have seconds to make a decision, you aren't going to obtain informed consent in that situation. So it's a question of, can informed consent be reasonably implied? Will obtaining informed consent significantly harm the patient? But as a general rule, it's completely correct that if you can obtain it without harming the patient, you should.
And the GMC guidance, which you've referred to in your report about the scope of permissible treatment in an emergency, suggests that the treatment should be limited to what's immediately necessary to save life or avoid significant deterioration of health, and should be the least restrictive of the patient's future choices. Does that, in your view, correctly reflect the ethical position?
I think it does. And there is a bit of a problem here, of course, for physicians or surgeons, because a definition of what is an emergency or what is urgent is extremely vague, and at times it can be misinterpreted to include things that actually aren't required at the time. Surgery that can be put off for a longer period of time, transfusions that are actually not necessary for a series of hours as opposed to ones that are necessary immediately. So I think it is beholden upon the clinician to make an assessment about what actually is required at that particular time and what needs to be urgently administered for that patient's best interests.
If treatment is undertaken without informed consent because it is a genuine emergency, that where there are only seconds or minutes and there is no means of obtaining informed consent, the patient may be unconscious, for example, is there then an ethical obligation, once, assuming the patient recovers, regains consciousness and is able to engage in dialogue with the clinician, is there then an ethical obligation to ensure that the patient is informed what treatment they have received, blood transfusion, surgery, nature of surgery, and informed at that stage of what the risks were, so that even though those risks may already have been run, they know to, for example, see whether their health requires to be monitored on an ongoing basis or whether they need to make lifestyle adaptations? Professor Carey. Professor Parsides.
Sorry, I think it's clear that that sort of explanation would be necessary. And I'd just add one more potential element to the decision making in an emergency situation. Some people have referred in the past to the notion of hypothetical consent, which is bringing a judgment of reasonableness to the measures that you take in an emergency situation, so that you think you are doing something that the patient would reasonably accept, then you feel more secure in what you're doing. And when you come to the explanation afterwards, hopefully there is the possibility of someone understanding quite easily why you took those steps and only those steps in the emergency situation.
And is there also an ethical obligation to ensure that treatment received without consent because of a genuine emergency is properly documented and recorded in the patient's records, so that there is a clear explanation of what the patient received and why, and what possible risks that might lead to?
To me,
absolutely there is. Sorry, Bobby.
No, you go ahead, Ian.
Well, please follow on from me. I think there's absolutely an obligation to record that, but of course the other part of this scenario that we're missing is that in emergency settings, almost all of the time, certainly in hospital settings, there isn't a single clinician there. There are many people around, and it's often in fact the case that there'll be a group of health professionals who are administering urgent treatment to the patient, and at the same time there is invariably someone whose task it is to be speaking with the surrogate decision makers, the family members, the loved ones, the carers, who can be involved in that consent process contemporaneously. And again, that may be truncated in some way, but that certainly can continue at the time that emergency treatment is being offered. So taking someone's partner aside and explaining what needs to be done and why it needs to be done urgently and what the options are, that sorts of decision can very reasonably take place, and invariably does. And that also can then be documented in the record as to who was involved in the decision making at the time, what were they told, what did they understand. And then when the person who's received that treatment regains capacity, then they can be fully informed as to what's actually occurred.
Professor Parsides.
That's fine. I was simply affirming what you said earlier.
And then more broadly, so this question is not limited to emergency situations. Is it ever ethically acceptable not to tell a capacitous patient about risks, or to falsely advise a patient that a treatment is safe, for fear that the patient will decline the recommended treatment, a course which the clinician believes is not in their best interests?
I don't think that's...
Dr. Kazarian.
I don't think that would be ethical. And like we said yesterday, the patient needs to be informed of the risks, particularly the risks that are material to them, that are significant to them. So it will be important to inform the patient, even if that might mean that they refuse this particular treatment.
Professor
The
Khan?
only
Yes.
circumstance I could imagine where something like that might operate is where treatment of one person is necessary to protect others in a public health emergency. But there, I think you would have to invoke a legal instrument to treat the person against their will. So I think it could never be the case that if you have capacity and the treatment is being proposed in your interests, that you could fail to give informed consent.
Professor Cave?
Let me just add, yes, the therapeutic exception only applies in the case where there is likely to be serious harm to the patient, and the scenario that you set out doesn't involve there being serious harm.
If I may just comment, and tell me please if you think this is wrong, but in the scenario which was posed by Ms. Richards, in effect, the clinician is taking the decision for the patient, because he knows, or she knows, what the patient really wants, or at least suspects what they might really want, and is using knowledge as a form of control, denying knowledge in this case, in order to ensure that the patient takes a decision which, had they been fully informed, he thinks they would not have taken. So it's totally objectionable, isn't it?
Yes.
Absolutely.
Yes. And certainly none of that would provide a basis for lying to somebody, so deceiving them about the safety or otherwise of the test. Even the therapeutic privilege doesn't allow you to lie. It may allow you to withhold some information, but it certainly doesn't allow you to lie.
And unless
yes.
at some point raised the issue of risk and associated that with the treatment that you're assuming the patient wants because of their wishes and the outcome that they hope for, you don't know whether that is actually what they want, because they have the right and the ability to weigh up the significance of that risk against their overall goals.
It's well established that people can refuse even life-saving treatment. It couldn't be the case that any kind of benefit to the patient would warrant overriding their consent.
The other thing, so Brian, you mentioned the clinician making an assumption about what the patient would want because of how well they know that patient. I mean, Bobby's an empirical ethicist, but there's a huge amount of literature that suggests that clinicians are rubbish at predicting, or knowing full well what patients want by a genuine and deep knowledge of their values. I mean, I might say other health professionals are also rubbish, sometimes slightly less, but doctors are particularly bad at it. But even patients' loved ones are also particularly bad at knowing full well what someone would want. So all of this provides empirical support for the idea that you have to have that conversation.
I'm going to ask next about testing. Testing for infection. You've dealt with it in some detail in your report, and we discussed what I think are the applicable principles yesterday, so I may be able to take this relatively shortly. As I understand your report, if a test for a condition, whether it's hepatitis or HIV or some other infection or condition, is available, and assuming it's available on the NHS, it's up to a patient to decide whether or not to have that test because of the autonomy principle as articulated by you yesterday. Is that correct?
Yes.
And so you've said in your report, it's not ethical to test a person with capacity for such a condition without their consent. Are there any circumstances, for the moment leaving aside public health emergencies, I'll come back to that, are there any circumstances in which you can consider it could be ethical to test a person with capacity for a condition of that kind without their consent?
Well, here I think you need to distinguish between implicit and explicit consent. And certainly, 30 years ago, when I was practicing, I saw tests ordered for patients without their explicit consent. For example, syphilis serology was regularly ordered and ordered on pregnant women without their explicit consent. And the idea was that people come for healthcare and the doctor is ordering the tests that are necessary for their healthcare or their fetus's health. Around the 1980s, at the time of HIV, that expectation changed and it no longer became reasonable to imply consent for certain kinds of tests. But certainly, most tests people don't provide explicit consent for. And in the past, those included controversial tests like syphilis serology. I don't know, Ian, if you agree with that.
No, I would agree with it. And I suppose it goes to the specificity or the extent of consent. When most patients come into contact with a health service, they may not in an emergency situation, but in sort of less emergent situations, they might have a range of blood tests which might include 50 different indices. Testing a whole range of organ system function and electrolytes and bone marrow function, immunological function and the like. And it's generally not the case that patients are asked for explicit consent for each of those indices. They're asked for a broad consent, if you want, for health testing in the context of medical treatment, not so much specific testing.
I think that's a really helpful example as well, because conducting research around the year 2000 on antenatal screening and testing, there had been this comfortable system where you presented as a pregnant woman and you just accepted the tests that were taken in the understanding that they were to benefit you and the fetus and your subsequent child. And yet syphilis, which would be a very stigmatizing condition to reveal and one that could cause family disruption, wasn't commented on. But the emergence of an HIV test in an antenatal setting was thought to be something that did need to then bring in discussion about the extent to which you specified the tests that you agreed to in pregnancy. So I think, again, going back to one of the questions yesterday, this was a context within which the emergence of HIV did change practice.
Just to follow up on that point, if I may, there are varying ways in which consent can be obtained. So in relation to certain blood-borne viruses, there is, in some settings, the possibility of an opt-out consent, where, for example, in antenatal appointments, in the first appointment, consent will be sought from a patient, asking if they're willing to be tested for HIV and explaining why. And then it could be that they would agree that in subsequent appointments, without having to go through that again for the duration of pregnancy, then the same sort of tests might occur. And my understanding is that the same sort of thing has happened in prisons. And part of this is to ensure that there isn't that there isn't a problem with missing too many opportunities to treat as early as possible for patients that might be particularly high risk in relation to the prison setting.
What I understand from Professor Kerridge's answer that there may be good practical reasons why, if a suite of 50 tests are being performed upon a blood sample, a clinician may not wish to be explaining what each and every test is for, what each and every test entails. What's the qualitative difference in ethical terms between that and what is the now, as I understand it, generally accepted position and accepted at least from the 1980s, on the basis of your evidence, for treating testing for HIV or for syphilis or for hepatitis differently?
The implications of having abnormal, say, liver function are vastly different to the implications of having HIV for your life, for stigmatisation, for employment, for insurance, for a whole range of aspects of your life. It is
for others.
And for others. So it is, a qualitatively different kind of test. Just as genetic tests are treated differently to other tests, so HIV and indeed I think syphilis would be treated differently than your liver function tests or your kidney function tests or your level of anemia.
I think just to follow that up, the determining what types of tests require specific consent and what types of things can be covered by broader consent, if you want, that's certainly changed over time. Sometimes for very good reason, like the reasons now that we do get explicit consent for testing for infectious diseases that may be passaged by blood. Sometimes for cultural or historical reasons because of stigma attached to particular test results, and sometimes just because of changes in science and things that seemed significant previously become less significant, things believed not so significant become more significant with developments in science.
And you've identified in your report, in the context of testing for infection, the kind of information that should be provided by the clinician. And I'll just, in fact, I will put that on screen because I think it might be useful just for others to follow the text. Shomi, could we have the expert report on the screen, please? The internal pagination is page 63. Yes. It'll probably be page 67 electronically. It's page 63 if you look at the page numbers at the bottom. So if you go back, it's page 63 using the pagination at the bottom, please. Thank you. So if we look at the list of bullet points there, you've said this, in the context of testing for infection, information should be provided about the nature of the test and its implication for well-being, whether experimental / unproven, information relating to both the test and the condition for which it's done. This includes medical indication, utility of the test, risks, the value of the knowledge, alternatives to testing, cost of the test, who does the testing, who will deal with the information, implications of testing, for example, for insurance and employment, the voluntary nature of the testing and ability to withdraw consent, obligations flowing from tests such as the obligation to inform others, confidentiality and its limits, public health and interest justifications for testing, any cost to the patient, the opportunity to ask questions and time to make a decision. So this would be what we would describe as pre-test counselling, is that correct? Professor Carriage?
Yes. Yes.
To what extent, you're addressing here, I think, the current understanding of the kind of processes that would be undertaken. Are you able to assist us with when, historically, a concept of some form of pre-test counselling, albeit not necessarily encompassing each and every one of these limbs, first became recognised by clinicians or indeed by ethicists?
Goodness. Broadly, I think there's no question that there's been a change in practice over time in terms of the type of information that's given to patients prior to testing. prior to the 1970s, 1980s, I think it's fair to say that there would have been very limited information of this kind given to patients prior to testing, whereas at the current time, most of these things would be discussed most of the time. There would be some, and I'd go to the second bullet point from the bottom, the costs to the patient. There's just been a report released here in Australia regarding financial consent to health, which is predicated around the idea that patients are given very little information about the costs of testing, the costs of treatment, alternatives, and out-of-pocket expenses and so forth, at least in this country. So at this stage already, there's already a number of things here that are not covered. But over the certainly 1980s, 1990s, and largely as a consequence of possibly two areas of practice. One was the identification of bloodborne infections, and particularly HIV, and the other was the emergence of an expansion of genetic testing. Is that the idea of pre-test counselling became much more a part of both ethical and clinical and legal dialogue.
Yeah, I think I agree with Ian. I think pre-test counselling has been a standard part of genetic testing since very early on. So I would say, at least from the early 1980s, it was a part of genetic counselling and standard for clinical genetics. But I would say that the late 1980s is when it became standard for HIV and infectious diseases, at least in Australia. But I suspect here as well. Professor
Cave?
Yes, just to add to that, I think the conversations that we've had yesterday about informed consent speak to this. It may not have been referred to in the 1980s as counselling as such, but there was recognition, certainly from 1988, that informed consent was needed for testing for infection. And informed consent was about giving the advice needed in order to be able to make a decision. And the list that you see there is the information that in that particular context was needed in order to be able to make an autonomous decision. So I think it will have had a different name perhaps, and won't have been spelt out in quite as much detail. But that's, I think, what was underlying it.
And the reference to 1988, is that a reference to the decision-making and recommendations and materials that emerged in 1988 in relation to HIV testing?
That's right. That's the GMC document I'm referring to, which made it clear that for testing as well as for treatment, informed consent was required.
Can I then turn to the question of telling a patient the result of a test? And again, I'm not here talking about the suite of 50 tests that might have been undertaken to assess the health of different aspects of bodily organs. But if a clinician has a test result for a diagnosable condition, such as HIV or hepatitis C, but it would presumably apply more generally, and assuming the patient is not exercising the right not to know, as they may do, for example, in Huntington's disease or some other scenarios. Would it ever have been ethical, is it ethical, not to tell the patient the result of that test, not to tell them their diagnosis?
No, I think once a diagnosis is known by the doctor, then the doctor needs to inform the patient, because as we said in our report, without that information, the patient cannot actually exercise their autonomous choice about what to do next, so what kind of treatment to explore, what kind of options to explore, and they will need accurate and transparent information about this particular diagnosis, and even if it means doing nothing.
And in the case of an infectious disease, sorry, Professor Savaleski.
I think that's true, but I think that they certainly have to offer to disclose the result to the patient and give the patient the choice whether they want to know the result. I'm not clear whether ethically it's required for them to tell the patient the result without first inviting the patient to express their preferences about knowing the result of that test. I think patients should know, but that again is a fringe position, and I think the standard position would be patients must be offered the opportunity to have that information if they want.
Professor Vossidis.
Sorry, this really relates to your previous question, but I think it now relates to what Julian said. I think a good example of the extent to which we feel a patient should be in control of information around testing for these sorts of conditions is what happens if there has been a needle stick injury in the context of medical treatment. Theoretically, with any patient, that raises the possibility of a healthcare professional, or as we often have to deal with, a medical student being put at risk of infectious disease. It is still absolutely imperative that the patient is asked whether or not a test can be conducted, and also it's discussed with them what to do with the results of that test. And if a patient refuses, then in practical terms, it means 3 months of prophylactic treatment for the healthcare professional, a lot of uncertainty, but that's an absolute red line in the sand. So I think the fact that even when we can see that a direct risk to others sitting alongside a decision not to be tested, we still leave that decision with the patient.
Yes, Professor Cave.
We've discussed the possibility that, contrary to ethical advice, some patients may not have been aware that they'd been tested. If empirically we imagine that situation, and then we look at the theoretical possibility that actually there was potentially insufficient certainty about that test and what it means at a particular point, if, in theory, it was felt at that particular point of time that there was no direct risk to the patient or to others, and that there was nothing that a patient could do or anybody else could do, then you could construct a situation whereby a clinician might have thought it wasn't in the best interest of the patient to know a particular result. But we really are building theory on top of theory and fiction on top of fiction there. I think it's very unlikely that you'll get a situation where all those things occurred. But I just wanted to make the point that there may be some situations where, given the level of paternalism at the time, that there were other factors that might have been brought into making this decision about when or whether to tell a patient this information.
And I wonder if, I wonder if Ian would also agree that sometimes a clinician might come under pressure from family members in terms of disclosure of all sorts of medical information. And if something is seen as particularly stigmatizing or a difficult diagnosis to manage socially, it may well be that the clinician has been directly approached by family members on this issue.
Yes, but yeah, thanks, Bobby. That's actually very common in this part of the world. Not so much, interestingly, in relation to infectious diseases, which maybe in the West are intensely stigmatizing, but in relation to cancer diagnoses, in Vietnamese populations, so some Southeast Asian populations, in some parts of China, there's a huge family pressure not to disclose cancer diagnoses to older parents, but for that information to be retained by their children as a way of sort of managing the hope and expectations and life goals of the parents, and allow the family unit the autonomous control of that information. And that can be a really difficult situation for physicians. The College of Physicians here in Australia has actually just taken this seriously enough that they've produced some guidance and educational resources for junior doctors as to how to deal with that or mediate that type of conflict.
But presumably in the kind of scenario that you described, Professor Kerridge, although practically it may be an extremely difficult situation for the clinician to manage, ethically there's really only one answer in light of the principles that you've all been articulating, which is it's the patient's decision, not their child or any other family member.
No, I disagree. I don't think it is quite so clear. I think there may be very good reasons arising out of cultural respect to actually accept that there may be different ideas about autonomy, and there may be different approaches to giving information. We may still want to give that diagnosis to an aged person, but it may be reasonable under that circumstance to spend days, weeks, having conversations about how that information could be given, encouraging people to think through the implications of not giving that information. So I don't think it's completely clear that you would immediately adapt the idea that autonomous person must know that information in all circumstances.
I would
very strong.
Disagree with Ian, my colleague there. So
I was waiting for that.
Well, I agree with you. You might take some time to understand how to give the information. I completely agree with that. But I do believe that in the end, that person should have the opportunity themselves to make a decision, at least, about whether to receive that information or not. So we have a disagreement, and I think it's a reasonable disagreement.
May I ask a question here? The hypothesis that a clinician may, as it were, hide the test result from a patient, which Professor Kay mentioned, means that the patient won't be told there is a result. If the patient is going to exercise autonomy properly, don't they need to know that there is a result before they're asked, in effect, whether they want to know it or not? And is perhaps the answer to the cultural question of certain communities where there may be different cultures, that if the patient is aware there is a result, he may say, well, don't tell me, tell my children.
Yes.
Yes.
And if people receive information they don't want, they have many psychological mechanisms of dealing with it and putting it to the side as well. But you're exactly right. They can make a choice about who has that information. So I have to disagree with Ian on this. I think that it's a person's right to know about their life to the extent that they want to.
So I think Sir Brian's point is a helpful one, because if you stage the discussion and start with the introduction of the idea of a test, you can put the brake on there in terms of discussing what will be done as a result of the test. If you haven't been open about the fact that you are testing for X or Y, then you have to do all the subtle cultural negotiation that Ian sets out at the time of the result already being held. So I think one of the features of genetic counselling, which has been referred to, is that there is a lot of preparatory work to be done to introduce people to the idea of what is entailed before the test is undertaken, and then further work around the sharing and interpretation of the results.
Professor
Just
Kay.
wanted to add that the point I made very briefly was explanatory rather than justificatory. I wasn't, because we have stated very clearly that we think there should be openness about the fact that there was a test and about the test results.
We talked yesterday about moral relativism, and I think this is a good case where cultural relativism comes up against what has been called in the report moral objectivism. And that's just, a fundamental philosophical disagreement. And I think there are some values, and that's the movement of universal human rights, and in particularly respect for people's autonomy that cross cultures. And I think this is a very good example where you have to go on one side of the fence.
Maybe just to clarify, I actually agree with Julian. I wasn't necessarily arguing for non-disclosure, but just arguing against the idea of simplicity and suggesting that there might be a long and involved conversation, but I do think it is the individual's right to have that information. But I think it's possible, and it's just to take up moral relativism, I think it's possible to respect cultural differences and cultural norms while at the same time not completely acceding to them. So cultural respect means that we could listen to a different cultural viewpoint about the types of information people would like to be given to their parents and so forth, and that can be respected and listened to and engaged with over a long period of time. But respecting that cultural norm doesn't mean necessarily being a slave to it. And I think that's sometimes confused.
I agree.
In your report, you identify in terms of the ethical obligation to tell a patient the result of a test, not only the autonomy principle, but in the context of infectious diseases, also the potential risk to others and the rights of others. Can I ask for your assistance with this in that context, so infectious diseases where others might be at risk, and the right not to know? If you have a patient who you know has been tested for and diagnosed with a highly infectious disease which they are at risk of passing on to others, and that patient exercises the right not to know, what are the obligations, both ethically and practically, of the clinician in that regard? Dr. Kazarian.
So, as you said, in that context, the information to the patient is important because there is a risk that this particular patient might infect others, and therefore information is actually protecting not only the patient but also their loved ones. So it is important to inform the patient. However, if the patient refuses that information, it will be for the clinician to decide what to do and to explain to the patient that actually non-disclosure will be dangerous to their loved ones as well. So it might be a matter of giving time and space to the patient in order to process that information, to understand what's at stake, and maybe ask the patient if they would like to see some other members of the team to explain things further, to have a bit more support. So there's a whole process that needs to be put in place in order to help the patient understand what could happen if they're not informed. So at the end of the day, if it is a matter of protecting third parties, other people, then yes, the doctor will need to make a choice as to whether or not they need to inform that patient.
Ethically, is there an answer to the question of what the clinician should do at that stage? If one assumes the clinician has made every effort to engage with the patient potentially over a reasonably significant period of time, to persuade them of the importance of them being given information about their diagnosis and its implications, to no avail because the patient continues to exercise the right not to know. Does ethics provide an answer to the clinician then? Are they entitled to go to the patient's partner and say your husband has HIV?
So I mentioned yesterday the concept of moral responsibility, which is a function of the avoidability of harm and the foreseeability. So this is a case where if the doctor can avoid the harm to a third party and can foresee it, if they don't act, they're morally responsible for the harm that occurs. So here they have to weigh the magnitude of the harm and how likely it is against the failure to respect the patient's autonomy. So if the risk of harm is non-trivial and the harm is great, it seems to me there's a clear moral responsibility to act. And if there's a legal mechanism of enabling them to act, they should act, unless the likelihood of harm is very small.
Professor Kay, do you have any reflections from the legal perspective?
Well, it will depend in part on the relationship between the doctor and the partner, or partners as may be. If the partner is also a patient of the doctor, then the doctor owes a duty of care to that patient too. in which case there may be some circumstances where it's acceptable to breach the duty of confidentiality in the public interest in order to protect another. But doctors aren't detectives. They're not able to know, they won't necessarily know who else is at risk, or to be able to track them down and give them that information. So unless, as Julian said, there's a legal mechanism, then the primary duty is to persuade, because there are practical impediments to doing much more in some situations.
Professor Carriage.
If I could add to that, I think ethics is really helpful in these kind of situations, because it does provide the basis for disclosing test results without the consent of the individual who's been tested. But at the same time, it says that to do that is a very significant act. So therefore, you have to go through a series of steps. So you can't just go straight to that end point. You'd have to start by having a proper process of pre-test counselling. Once you have the test result, the tested result has to be explained to the patient and information given to them about what it means and also what the implications are for others. You then give them time to understand that, and then you could again say, look, this has implications for others, and you might then move to strong persuasion if you want, saying, look, we would really ask you to do this because we think that you have a moral obligation to do so, and we have a moral obligation to take into account the risks to others. And finally, then you might get to a point of actually going to someone who's recognisable, who's close, and who has a definable risk of not knowing that information and then disclosing that information to them. The other concept that I think is helpful here is one that Grant Gillett, a New Zealand philosopher, came up with, which is the concept of moral freeloading, which I love in this context. So this is the idea that it's quite objectionable for a patient to say, you have to respect my moral right not to know this information, but I'm not going to respect the moral right of others to be protected from harm, and I'm not going to recognise your moral responsibility. So everybody has to recognise mine, but I'm not recognising any moral obligations or duties that I have to others. And he says it's reasonable to say to people that's actually quite an objectionable argument. It certainly runs against social solidarity, it runs against reciprocity, it runs against communitarianism, and it runs against respect for others.
Well, I would, again, just slightly qualify what Ian said. I think there are significant harms to the person of that information being released, and they may have very valid reasons to say, I don't want to know. And I think you have to acknowledge that you are going to harm that person to benefit another. And unfortunately, that's what ethics deals with and justice deals with, distributing harms and benefits amongst different people. And in this case, the doctor does have a moral responsibility to others besides his or her patient. But I think you know, saying that it's moral freeloading, I think is diminishing the harm that is done to the person who's doesn't want to know this information and may be significantly harmed by it.
From an ethical perspective, or what does ethics have to assist us with understanding how information about a diagnosis should be communicated to a patient? So a diagnosis of a serious condition, such as HIV or hepatitis C, or indeed some of the conditions that you referred to in your evidence elsewhere, cancer. How ethically should the clinician go about providing that diagnosis and information to the patient? Professor Fasidis?
Yes, one of the ethical responsibilities that precedes any conversation with a particular patient is to be well aware of what a social psychologist might call the social representations of the particular disease or condition in question, so that the clinician understands the sensitivities, understands what in other contexts might seem a very unusual wish not to know about this thing or not to share information with others. So that going back to our discussion yesterday of keeping up with your education, there's a sense in which if you're working in a particular field, you want to understand what we sometimes call the ethical landscape, what matters to people, what people are scared of, what the implications of knowledge are for people, and what the implications of not knowing are, the extent to which it is a purely personal decision with only personal repercussions, and the extent to which it will necessarily have an impact on others. So I think even before you go into the discussion, if you're working in a field where you know that you're going to be probably repeatedly put in a position of giving people information that they really rather would not have, you need to understand at a sort of sociological, cultural level what that means. And at that point, I hand over to my clinician colleagues to say something more specific about the actual encounter that might follow.
Professor Carriage?
I'm happy to offer a little bit here, Julian, if you want.
No, you're the clinician.
No, it's. I think this is one of the areas where law, ethics, and professional practice are almost in complete alignment. Because there's now most of the colleges or medical associations give very explicit advice about the kinds of information that needs to be given about diagnosis, including its classification, its stage, its prognosis, its etiology, its treatment, its risks and benefits, its expected outcomes, the costs, the processes, who's involved, et cetera, et cetera. So it's a huge amount of information, I think, that follows from a diagnosis rather than just the diagnosis. But that's just all the factual information. It also goes, the type of thing that Bobby's talking about is that it needs to be given in a way that it's meaningful for the person involved, and that involves according to the style of delivery that they will want. Some people might like more or less detailed information. Some might like diagrams. Others might like quantitative or more qualitative information, and it may need to be given in a whole series of different genres, and it may need to be given over a long period of time. So I think this is really an area where we've got, I think, quite strong agreement of the necessity to give this information, to give it appropriately, to give it sensitively, and to give it over repeated periods of time and with lots of opportunity for clarification.
And what's the role of candour and honesty in that process?
Bobby?
Well, some philosophers have chosen to substitute those terms with the term truthfulness. So it's a sense of judging the amount of information someone can deal with at any time. So the whole truth is not necessarily to be put on the table right at the beginning of coming to terms with a particular diagnosis. But there is a basic level of information without which someone will simply not understand where they're at the moment and what the implications of this diagnosis are. So, there are many examples of bad communication that is not about withholding, but about dumping all the difficult information on a patient, because as we discussed yesterday, it's not easy to give people difficult, bad news. You want to give people hope, you want to give them a sense that you are going to make things better, and that's not always possible. So I think it's very much bespoke, as Ian said. It's reading the signs from the patient that you're dealing with about what they may already be thinking and worrying about, what you may need to dispel in terms of false understandings or fears, but a gentle process that is, again, going back to the term that the GMC want us to think about in terms of any medical decision making, based on meaningful communication and meaningful dialogue between the doctor and the patient.
Degree of candor would be
yes.
particularly relevant, especially if the infection was caused by a particular product that was given to the patient. And so therefore the doctor, the clinician, has a duty to be frank and honest with the patients, to explain what happens, and to explain that there might be uncertainties about what has happened, and the type of options that the patient now has after that the information is given to them.
And I think it probably follows from discussions that we were having yesterday, that if the cause of the infection is the treatment which the patient has been receiving, there is an ethical obligation for that information to be shared with the patient, albeit there may be issues depending upon the patient's presentation, state, degree of shock, etc. Maybe issues of timing as to how and when you provide that information, but patients should be told ethically if it's their medical treatment that has infected them. Is that right?
Absolutely.
Clinicians shouldn't be concerned about protecting their own interest, because it's the patient's life that matters first.
Yeah,
Professor
there
Fossey,
has to be openness and transparency. I think we were all agreed on that yesterday.
I would just add, we are all agreed, and I agree too. Truth telling is a central ethical duty. But just to add that it's conspicuous in its absence from certain professional guidelines and from the law until fairly recently. So it's only recently become become a statutory requirement as the duty of candour. And I think that's quite telling that it's taken so long for that to happen.
I think it's had a much longer history in ethical codes in some ways, and it was, I mean, sometimes the Beecham and Childress principles are referred to as 4, sometimes as 6 principles, and I think the 5th principle is veracity or truth-telling or honest disclosure. So certainly within bioethics, it's got a longer scholarship, and within professional codes, there's at least some suggestion of truthful disclosure in some of the more ancient codes as well.
I mean, from an ethical perspective, the goal is that the patient understands the situation and is able to navigate their life and the options that are available to them. So if you're not fully candid and including not telling the origin of the infection, you will close off options such as the ability to seek rectification, the ability to exercise their legal rights, and various other options that they're entitled to, even though the pursuit of those options will go against the interests of the doctor or the health system. But those are genuine options the patient has, and the decision not to enable the patient to pursue them is a violation of their autonomy.
And then we've already discussed. Sorry, yes.
Sorry, yes. I just think, in that sense, truth-telling is not just about consent, of course. I mean, it's a mark of a health professional-patient relationship, and it's an expected virtue of health professionals as well. I mean, we expect it in relationships that we have at home, with our loved ones, and we certainly would expect it as a virtue in a healthcare setting, and it's a fundamental plank of a doctor-patient relationship.
We've discussed this morning the ethical considerations that come into play in terms of potentially telling a partner, in the absence of the patient's consent, about the patient's infection. More broadly, to what other third parties could it be ethical to provide information about a patient's infection in the absence of their consent, assuming capacity? Professor Cave?
Well, in our report, we looked at 2 other possibilities in particular. One is that the information might be given to other healthcare professionals, and the other is that in some situations it might be passed on to the child's school. And we noted that there was a report from the Council of Europe which recommended respecting confidentiality insofar as information should only ever be given to a child's school either with consent or where it was very clear that it was in the best interests of the child in order to do that. Similarly, with regards to healthcare professionals, the preferred approach was to persuade rather than to force, and to only go ahead with telling another healthcare professional if not doing so would put that healthcare professional at serious risk.
And I think it would follow from that that it must be unethical to tell a third party of a patient's diagnosis without having actually even asked the patient for consent in the first place.
Yes, I think that would be right.
Yeah.
Then just ask you a little about.
May I just ask what I think is probably a very simple question? But doctors, whether in hospital or in a surgery, a GP surgery, will generally act with and communicate with the help of secretaries or receptionists. Is it a breach of the duty which they owe the patient that the typist, the secretary, may be typing up a letter which describes a condition about which he had not been typing, if she or he had not been typing it up, they would not have known. Or the receptionist knows, but in order to make an appointment, of a condition which they would not have known about had they not been informed for that purpose.
I think this is a very tricky area, and many years ago I used to be invited to a European course which was specifically for receptionists and medical secretaries to discuss with them the ethical responsibilities in their work. But that was a highly unusual event. And I think there's an added problem in that the people in question are often members of the community within which they work. So local knowledge, it might mean that they can actually identify patients rather than it just being a name or an address on a letter. So I think certainly there were discussions in the early days around HIV of how you could impart upon people who came in touch with this information, who didn't have the same sort of grounding and education in their specifically ethical responsibilities to deal with it responsibly. For example, taking a death certificate to a building society that has a sensitive or potentially stigmatizing cause of death written on it, you would want to be assured again that there would be confidentiality in the community, but this is probably something that people haven't previously had to think about. So I have to say, I think you ask a very interesting and difficult question, and one where we might remain with some disquiet because we have not gone to great lengths to offer direct and very specific training or guidance to people in that position. One only has to hope that, for example, in a GP setting, senior partners would see it as very much their responsibility to induct staff into questions and talk to them about confidentiality. Patients are sensitive to this. There was a drive a couple of years ago to ask GP receptionists to request people to sign up onto the organ donation register when they came for an appointment. And that policy was dropped quite quickly because people felt they didn't want that person to know whether they had or had not done this thing. It was personal to them. So I don't have an answer, but I recognise a problem there.
Sorry.
Julian.
Well, just two things I said yesterday I think are applicable. In an ideal world, receptionists and typists wouldn't be involved in these confidential matters. But as I said yesterday, ought implies can, and there are extraordinary limitations on the NHS, and whether it would be reasonable to expect that level of confidentiality to be achieved with the resources available, I just don't know the answer to that. But we've made voluminous recommendations in our report, or made many, many claims. How far those are achievable within the constraints, the resource limitations of the NHS is, I think, a major question. And I do think we at some point need to address those sorts of constraints on what can be reasonably achieved. But yes, in an ideal world, they wouldn't be involved.
I think
so Brian, I could also... Oh, sorry, Anne. No, you go.
I just wanted to add just a very brief legal point that they would, I think, be under a legal duty to protect the patient's confidentiality, but they wouldn't be bound by the professional code, the professional codes that apply to doctors. That was the point I wanted to make. Go ahead, Ian.
No, that's. I mean, I think my point adds to this. I mean, Sir Brian, there's 30 years ago, there's a very famous paper published in the New England Journal of Medicine by Mark Siegler called Confidentiality, a Decrepit Concept in Medicine, in which he pointed out that a promise given to a patient to keep one piece of information, say their diagnosis, whether it was HIV or a cancer diagnosis or a stigmatizing disease, the promise to keep that confidential is very hard to sustain, because in any one day, a patient, an inpatient in a hospital will have contact with somewhere between 30 and 60 health professionals, let alone other people, whether they're receptionists or ward clerks or what have you. So an enormous number of people who may have varying degrees of awareness of their ethical responsibilities and varying relationships with the person whose knowledge is being kept confidential. So Julian's point about what's genuinely achievable and what promise should be offered to somebody in terms of the degree to which confidentiality can be respected, I think that's a really important conversation that needs to be had.
But do you not think it could be a basic component of the induction to working in any healthcare setting to put it glibly, what happens in the hospital stays in the hospital, what happens in the GP practice stays in the GP practice? And if you don't bother to underline that and reiterate it and make sure that people do the best they possibly can, then the fact that you have a legal obligation and your staff have a legal obligation, it becomes quite worrying that you haven't made those very basic efforts.
Yeah, no, I think all of that needs to be done. I don't know necessarily that it removes the complexity, but I think, you know, it's made very clear to all health employees when they come in to work in a hospital, whether it's in the NHS or an incredibly well-resourced hospital in some far-off land, the ethical responsibilities they have to maintain confidentiality. Hospital record systems have been adjusted to accommodate this already. Many hospitals, if there are certain diagnoses, HIV being one, is that's only acceptable to, or only accessible rather, to certain access codes. And so that might be the patient's primary clinician, or in many hospitals, it's actually medical staff, but not nursing staff, which is sort of an interesting distinction in a way, because it's not, you know, a doctor who has nothing to do with someone, the idea that they should have access, but a nurse who's have a lot to do with someone shouldn't have access is a bit odd. So I think there's a whole range of ways that confidentiality can be protected, but I just don't know that they give us the surety of saying is that it doesn't go further than an individual.
And then, ethically, do the principles governing respect for patients' confidentiality, non-disclosure of information, save in certain circumstances, do they alter following the patient's death? And if so, how?
No, the doctor has a duty of confidentiality after the patient's death. That's the reason one reason for this is because if confidentiality didn't survive death, then the trust between the doctor and the patient would be breached, and patients would not want to actually tell the doctor a lot of different things about themselves if they knew that this would be disclosed after their death. So it's a very important principle that confidentiality survives the death of the patient, and also to respect that patient's information and to not disclose it to other parties.
That's absolutely right. The GMC does recognise that there are times when information can be passed on, though. So it recommends in its guidance on confidentiality that first there is consideration of what the patient wanted, and if there's no evidence of that, then look to possible distress to the family of releasing certain information, and it's recognised that that will often diminish over time. Another thing to look at is whether it's already public knowledge and whether the information in question can be anonymised, and what the purposes are for disclosure. So it's not a sort of hard and fast rule that information can never be passed on, but Melanie is absolutely right that the duty of confidentiality, ethically and potentially legally as well, goes beyond death.
I want to ask you, finally on this topic and before we break, about storage of blood samples without patients' knowledge or consent. To what extent has it ever been, or is it now ethical for there to be stored samples of a patient's blood kept for possible future testing without the patient knowing about it or having consented to that?
It's I think there are some circumstances where it's ethically relatively unproblematic for blood to be retained and used without somebody's consent. That certainly has been in the past and continues that way. And there's probably two that are relatively unproblematic. The first is for legal reasons. So blood alcohol testing in the context of car accidents, for example, whether a patient consents to their blood being taken and stored for subsequent testing is generally irrelevant, and the law overrides a patient's consent. And there's other situations where that's the case legally as well. The other is, though, in the healthcare setting, is for quality assurance and laboratory processing. So it's been the case for many decades that when people donate blood to a blood service, that a certain percentage of that blood is used to maintain quality control of instruments in the laboratories and in the blood service. And that type of quality assurance and laboratory management is an incredibly important part of making sure that the blood service produces safe and high quality and high utility products. And that's often, or generally, it's been done without people's consent. There isn't any harm that arises to that to the patient. There's no risk, there's no retention, there's no further testing. So I think that's been relatively unproblematic previously, and to me at least, I think that continues to be unproblematic. Increasingly, though, it's regarded that retention of biotissues or blood samples for other reasons that are going to be tested or the subject of research without consent at some time and at some point and in some form rather, that's increasingly regarded as being unethical.
Professor Farsidis?
I just wondered whether it's also worth talking about whether or not those samples immediately become de-identified and detached from a patient's clinical notes and history. So you might think differently about, as Ian's put it, a spare amount of blood going to a very good practical purpose without that being in any way associated back to the patient who provided that blood. If, however, as Ian again said, you store it and you keep it very much identified with that particular patient and subsequently conduct tests that reveal information relevant to that patient, you find yourself in a terribly difficult ethical position when the results come back.
I think it depends on what the patient's expectations were and what they understood at the time they gave the specimen. So, for example, if I gave a specimen for a diagnosis of a cancer, I would expect that if there were improvements in the future in the diagnosis of that cancer, or maybe better specification of the types of cancer that was relevant to my ongoing care, that my specimen would be retested and I would be informed of the results of that. However, as Ian said, if I wasn't told that a specimen would be used for research purposes, and it was, that would be something that would be a violation of my autonomy. So, it really depends on what the person is understanding that they're doing. And I think it's a reasonable expectation that our, specimens will be used in various ways for testing, as Ian said, for quality assurance. But it really depends on what the future use or the purpose of the storage and the future use is.
Professor Kay.
If I can, please, in terms of context, databases are hugely important. Without them, it's often impossible to spot safety concerns or to undertake research. The Cumberledge Review, for example, has made clear that all sorts of problems with medicine and devices that we didn't manage to spot, we perhaps would have done if there had been good databases. So there is a very strong public interest in having these databases. As we've already discussed, anonymisation certainly reduces the ethical implications. It doesn't take them away entirely. There's still matters of trust and autonomy, but it does take away a significant number of issues, and it's broadly recognised that that data, so long as it's anonymised, can be stored. If it's used for research, it may require ethics committee approval, but it can potentially be stored without explicit consent. Even when it isn't anonymised, although explicit consent is optimal from an ethical point of view, there are legal exceptions to the requirement to get explicit consent even today. So, for example, in the coronavirus crisis, there have been regulations under Section 251 of the NHS Act requiring that confidential information is passed on so that they have the relevant information in order to be able to fight and respond and to react to the coronavirus crisis. Okay, so that's the basic point I wanted to make.
Picking up on Professor Savulescu's points, if a patient has never been told that blood taken from them is going to be stored in their name, so not de-identified, not anonymised, and has never been told that that blood may be tested for blood-borne infections or for other purposes at some future stage, it sounds to me from your answers as though that would be ethically problematic.
Yes, hugely problematic. I mean, it's then, and then obviously there's examples from many countries around the world where this absolute thing has taken place. It's then beholden upon the health service or the university or the museum or the laboratory to develop processes by which the people whose tissue has been retained or their relatives are then informed that this is the case and provided with the opportunity to make an autonomous decision about the management of that tissue at that point, even though consent hadn't been gained originally. And that would be done in different ways depending upon what the tissue is, who's retained it, and what type of sort of consent process is desirable.
And going back to what Emma said about the value of biobanks and repositories and registers, it's a terrible lost opportunity if you don't have good ethical values at the outset that mean that the people whose samples are included have in some real sense donated and become part of that enterprise. And in fact, I think some people get comfort ultimately from the fact that they were able to donate part of a cancer tumour or blood, and research has proceeded on the basis of that. Even in the darkest moments of the retained organ scandal in this country, many parents said, had they been asked in a sensitive way to donate their child's heart or other tissue samples, then, and been given a reason for that, being told the potential benefits that could follow from that, then actually, far from being something that they would have resented or found unbearable, it's something that might have helped them give some meaning to the terrible tragedy in their life. So I think, again, have to be careful not to make assumptions about what will happen around an issue like this.
So I know the time.
Just to take that a little bit further, because I mean, Julian gave an example of his own tissue being, cancer tissue being retained and tested at multiple points in the future, and Bobby's also talked about, and Emma's talked about the value of these biorepositories. That there's a really important issue in relation to consent there, because there may be a process, because science develops over time and tests change over time and tissue can be retained over a long period of time, that we don't actually require consent to be gained for every single test at every single point into the future. Is that it may be possible to respect autonomy by designing different consent processes up front. But that does require that people are informed that their tissue is being retained. They're given the opportunity, or not just the opportunity, they have complete control over whether that occurs. And they can say at that point what they consent to. And it may be that they could say, look, I consent to all future testing of my tissue relative to my particular disease, but not necessarily for other diseases, as long as that research project and that test has gone through an approved scientific and ethical review process. And there are concepts like broad consent and dynamic consent that have changed the type of consent to still make it ethically and legally robust, but also give it more scientific and civil utility.
Thank you. So given the time, and I'm going to move on to the issue of research, is this a convenient moment to take a break?
Yes, it is. We'll take a break until 10 to 12. 10 to 12.
Thank you.